All right, good afternoon, everyone, and happy Wednesday. Thank you all for joining us today on this wonderful day. We're going to first start off with an awareness presentation by one of our wonderful community educator, Paige.
Hello, everyone. Good afternoon. So welcome to today's program. It's Ask the Expert, Demystifying Article 81. My name is Paige Ellen, and I am a community educator volunteer. Let me just, sorry. Let's see. I'm sorry, I lost this. Okay. I'm a community educator with the Alzheimer's Association. And I volunteered, is very interested in learning more about it. Actually, recently it's been a sort of I've had personal effect from a family relative, so it's even more meaningful to me. Okay, so before we start with today's program, we can take a minute to look at a few facts and figures about Alzheimer's disease and consider how widespread the impact of Alzheimer's disease and dementia can be. So as you can see, the numbers are staggering. Nearly 7 million Americans are living with Alzheimer's. Over 11 million Americans are providing unpaid care for people living with the disease. And we know that Black Americans are 2 times as likely to develop Alzheimer's. Hispanic Americans are 1.5 times more likely to develop Alzheimer's, and Alzheimer's disproportionately affects women. So left unchecked, Alzheimer's will destroy our finances and our families and our futures. So the Alzheimer's Association mission is here to lead the way to end Alzheimer's and all other dementia by accelerating global research, driving risk reduction and early detection, and maximizing quality care and support. Okay. So just to make sure we're all on the same page, our mission references Alzheimer's and dementia. So while used interchangeably, we should talk about each term. So dementia is a general term for the loss of memory and thinking and language, problem solving, and other abilities that are severe enough to interfere with daily life. Dementia is not a single disease, it's rather an umbrella term like heart disease, and covers a wide range of specific medical conditions that includes Alzheimer's disease. Alzheimer's is the most common cause of dementia, and it's a progressive disease where symptoms gradually worsen over a number of years. While age is the greatest known risk factors, individuals under the age of 65 can also be diagnosed with Alzheimer's disease, and this is known as younger set Alzheimer's. Okay, so how we can help is if you notice any of the warning signs of Alzheimer's disease in yourself or someone you know, schedule an appointment with a doctor. The earlier someone is diagnosed, the more treatment options there are available. Some medications are only effective in the earlier stages of the disease, and know that we're here to provide support to you and your loved ones throughout the journey. How we can help, we have a 24/7 helpline. It's 800-272-3900, and it's available around the clock, 365 days a year. The service is free. Specialists and master's level clinicians offer confidential support and information to people living with dementia, caregivers, families, and the public. We offer early stage social engagement programs for those living with Alzheimer's and dementia, and education programs for the community at large. So please keep an eye out for an email with more information on our upcoming programs. So now I'd like to introduce our guest presenter. Dina Schwartz joined Project Guardianship as the director of New York State Guardianship Initiatives in May of 2022. She has a decade of Article 81 guardianship expertise and has focused her career on issues affecting older adults. She has developed curricula and presented workshops locally, statewide, nationally, focusing on person-centered services, decision-making, autonomy, and access to justice. So as an attorney with the New York State Department of Social Services, she brought Article 81 guardianship petitions for adult protective services clients. She was also on a team that determined whether clients met the guardianship standard and what less restrictive alternatives could prevent unnecessary guardianship. More recently, Dina led a diverse group of stakeholders, including government agencies, community organizations, guardians, doctors, social workers, and lawyers in responding to complex elder abuse cases at the New York City Elder Abuse Center at Weill Cornell Medicine. She had Harvard Law School and a Bachelor of Science in Anthropology from Tulane. So here is Dina.
Thank you, Paige, and thanks for the good little presentation in the beginning as well. I always appreciate learning more, so thank you. So thanks everyone for coming today. This is sort of the 2.0 version of a presentation that I did a couple of months ago, so I appreciate interest from those who were unable to make the first one. I am going to be sharing my screen shortly. I just want to mention there's a lot of material that I'm going to be going over today. I try to keep this sort of a general overview of guardianship, but even that level still has so much in it, and I want to make sure that people are leaving with more of an understanding than they came in with, right? Because that's the point. Why else would you be here? So I am going to be as clear as possible. If you have any questions that are sort of clarifying questions, like maybe I didn't explain something well, or you want to know something about a term, I'll try to answer those types of questions if you put them in the chat on the spot to the best of my ability. Otherwise, I will be answering especially bigger questions more towards the end. I also want to mention, I know some folks come to these workshops because they're dealing with issues that might be related to guardianship. Personally, those are very tough. This isn't really the forum to be going, one-on-one about people's personal questions related to guardianship. But at the end of this presentation, I'm going to give you a resource that you can use so that you can have one-on-one attention related to anything that you're personally dealing with guardianship. So I don't want you to think that I'm just casting it aside. I know there's a lot, and we have wonderful attorneys who can give you a lot of more personalized attention at a later time. All right, that all being said, I'm going to share my screen. Here we go. So today's topic is demystifying Article 81 guardianship. And just a little bit about the organization that I come from. It's Project Guardianship's mission to provide person-centered care for older adults and people with disabilities and mental illness who need help making decisions, and to transform the systems that support those people to help ensure safety, promote independence, preserve dignity, and advance racial and social justice. So my organization since 2005 has been actually acting as a court-appointed guardian, primarily to lower income adults and people without family and other supports. And we do specialize in keeping people in their homes and out of institutions, and when possible, restoring their rights. So that is one project that we have, but we also do research and provide education, like right now, and advocate for better policies and practices, because we know the guardianship system is definitely imperfect. And we also try to work to create services that can help prevent unnecessary guardianships. And I mention this because I want to make clear before we start that as far as decision-making supports go, guardianship is the most restrictive, and it has to be the last resort. The law says so. So all other options really do need to be explored before turning to guardianship. And we're going to talk about some of those options today. So basic overview, we're going to talk about what guardianship is, how does the process work, and then we're going to go through some alternatives, and then I'm going to talk to you a bit about our helpline. So what is Article 81 guardianship? You will notice that right under the title of this slide, I have a URL that's, in case people can't see, it's nycourts.gov/guardianship. This is actually a pretty new resource that we created with the courts. And it has lots of information on guardianship. It has videos. It can give you a lot of answers to questions you may have, and has a really wonderful resource guide, if I may toot my own horn, that will give you ideas on things to do to try to prevent guardianship, alternatives, even just as a caregiver. Sometimes there's something you want to do and you don't know how to start. The systems are also confusing. So I really recommend that as a resource. I worked with a committee on that for over a year. So take a look. So what is a guardian? A guardian is appointed by a court to make decisions for a person who can't meet their needs and is at risk of harm. A judge generally must find that a person is incapacitated as well. So it's not just about not meeting needs and being at risk of harm. There's this piece about incapacity that I think is the hardest part to understand. And so I'm going to go deeper into incapacity in a moment. But a big part of it is whether or not a person can recognize that they need help. Are they making their decisions from an informed place? There's also an option to consent to guardianship too, although less common. Another thing to know about guardianship is a guardian is given powers to make decisions for a person. And what that means is that there will be, if someone's a guardian, there will be a specific list of powers, and the guardian can make those decisions, but anything not in that list, the person can still make those decisions. It's only meant to be for things that that person cannot manage themselves. So for example, let's say a person is forgetting to pay bills, they're at risk of losing their home. We know that they haven't really been able to recognize that they need assistance. Any assistance someone has tried to provide, they've said no, and it comes from a place of them really not grasping they're at risk of losing their home. That person may end up getting a guardian to deal with their income and to stabilize that part in their life, but they can take care of their food, their daily activities, their socialization, etc. That guardian's not there to take over their life. So the guardian might be able to deal with income, maybe enter into some contracts, but anything related to personal care and personal life would be left to that person. So that's really the most basic of examples. By the way, if anyone is asking clarifying questions in the chat, I'm not sure if I'm able to see them the way my screen is set up. So if Stephanie or anyone wants to shout them out, let me know. So another thing about guardianship, it can always change. And I think that this is a misconception. Some people think someone has a guardian, they have that guardian forever. Not the case. Some people, sure, they may need one for the rest of their lives, depending on what condition there is. But if it's no longer needed, you can request for the court to end it. If less powers are needed, you can request that for it to be more limited. If more powers are needed, you can also request that. The law treats guardianship very seriously, and it really should only be placed if it's necessary. And that's also why the court considers it a last resort. They take it very seriously because it takes away the ability for a person to make some of their own decisions. I'm going to sound like a broken record a lot, but it's very important to remember this. The law requires that other options have been explored first. So when you go to court trying to get someone a guardian, the judge is going to ask, what else have you tried? Or what haven't you tried but you believe won't work? Tell me why. Otherwise, they are not going to appoint a guardian. So some things that you might think of are like powers of attorney, healthcare proxies, community resources. We're going to talk through some general ideas. And then finally, you've heard me mention court, judges, etc. You have to go to court to get a guardian. It involves filing papers, having a hearing. The process can be time consuming. It can be expensive if you're hiring an attorney. There are almost no free legal services to assist with these things, which is very frustrating. And I know difficult, not only for us, but for a lot of the folks who call us looking for help. As you've seen, we're working with the courts to make more information available, like on that website I shared earlier, but it's tough, and it's not an easy system, and the process is not easy either. So I'm just trying to tell the truth here, you know? So what powers can a guardian have? So they're in two buckets. There's personal needs powers, and then there's also property needs power. So some examples of personal needs: choosing where to live, deciding who provides care, making medical decisions. And property needs are maybe a little more obvious, like paying bills, dealing with income, dealing with contracts. One thing to note is that in New York, you can actually have two different guardians, one for property needs and one for personal needs. Something I should have mentioned earlier, and I don't mean to make things more confusing, is that there is another type of guardianship in New York State. This is called Article 81 guardianship. You'll often hear it called Article 81 guardianship for incapacitated adults. More formally, there's another one called 17A guardianship. It takes place in a different court, and it's solely for people with developmental disabilities and also traumatic brain injuries. That type of guardianship, not only are they only for those folks and based on diagnosis, it's also for people who require a guardian to have every single power. It's what's called a plenary guardianship. So anyone that becomes a guardian under that law, they can't pick and choose what powers they get. And so I just want that to be out there, that 17A is a different type of guardianship. And that's, while some of the things I'm talking about today, related to alternatives and things like that may apply, I'm not specifically talking about that. Sorry for that interlude. I know it's all confusing enough. Anyway, yes, so there's personal needs and then there's property needs. You can have two different guardians, one for each, but also a lot of times it's just one guardian that deals with both. So who gets a guardian? What are the requirements? The language is incredibly dense, but let's start with some of the language that's really in the law. Okay, so there are kind of four things that need to be shown for a guardian to be appointed. One, that the person cannot provide for personal needs or property management. Second, you need to show that the person is likely to suffer harm because of these unmet needs. Then you need to find that they're either incapacitated or that they consent. And then again, you have to show that all lesser restrictive measures to prevent harm have been exhausted. Since the language is dense and the requirements are vague, let's go through each bit by bit. So unmet needs, this one feels a little bit more obvious. You need to show that a person's needs aren't being met. We went through this a little bit with the powers, but personal needs are things like food, clothing, shelter, healthcare, living environment, dressing, bathing, things that are often referred to as activities of daily living or ADLs. And then property needs, things having to do with real estate, personal property, benefits, income, financial affairs. It's often easy to recognize when someone's needs aren't being met, right? But unmet needs is not enough just to get a guardian. You also need to show that due to these unmet needs, that they are likely to suffer harm. This is a little difficult. How do you show that? Unfortunately, it's vague. What does likely even mean, right? There's always questions about definitions of words in court. What is likely? Likely is generally accepted to mean strong, almost certain that harm will occur. But then the question is, what will the court consider as harm? I'll tell you some things that the court has not considered as harm alone. Things like poor hygiene or peculiar behavior or eating only unhealthy food. Those alone have been found by the court to not be enough to be considered harm in this guardianship context. The situation has to be strong enough for a judge to say, this person's ability to make their own decisions should be limited. And so we're talking about action or inaction that maybe are contributing to really bad health conditions. Like I mentioned before, maybe that someone's at risk of losing their home, financial exploitation, maybe someone's unable to safely live alone, but is declining any sort of care, risky behavior, like maybe going out into the snow in summer clothing and not understanding why that's unsafe for their body. We're talking about bigger things. Third is incapacity, which is definitely the most confusing portion of guardianship. Just to get this out of the way, yes, you can consent to a guardian. It's not extremely common, but if someone wants to have a guardian and has the capacity to do so, and can show that there is a need for them to have a guardian, they can consent, and they will be called a person in need of a guardian, or a PING. You might hear a person be referred to as a PING. Otherwise, though, a judge needs to find someone is incapacitated. And we're in for some more dense language here. So this means a person cannot adequately understand and appreciate the nature and consequences of an inability to provide for their needs. So how do we kind of unpack this language? Does this person understand the consequences of their decisions, of their action, of their inaction? And do they understand the resulting danger of decisions or inaction? Do they then recognize that they need help? Okay, if they're at risk of danger and there are all these services available offered, if there's family members offering assistance, can they recognize that they need help? It's hard to show this. It can be very hard to show this. And note that this is not something that you can show by just telling a judge that someone has a diagnosis of some sort of mental illness or of dementia, or a type of dementia or Alzheimer's. It's about being able to show the issues, often through storytelling and examples. The question related to incapacity is also incapacity related to what? You can be incapacitated related to one thing and not the other. This is why you can pick and choose power. So like some of the examples I was, when I was talking about harm, right? Let's say someone isn't receiving medical treatment or taking medication for a serious illness. So if we're thinking about incapacity related to that, is it because they cannot grasp how serious the illness is and what's happening because they're not taking the medication? Is the decision based on understanding reality, or have they made a decision based on information about their health and perhaps their family disagrees and says this is a bad decision? These situations are hard, but a person has a right to make what you may think is a bad decision, even if it puts them at risk of harm. The issue is whether they have the capacity to make those decisions and whether they have the capacity to assume the risk. Maybe some of you have heard the concept of dignity of risk. Folks who do not have a guardian live life every day being given the ability to assume risk. And we need to honor that, and we don't need to agree with the way that people live their lives. But it can be hard, and it can be a fine line. I see a question right now. I don't know if you can see it on my screen, sorry. Is it legal to show the judge video of the person's inaction or non-action to demonstrate incapacity, unmet needs? That's a very good question, Paige. I have seen, just anecdotally, people show photos. And because this is a court hearing, there had to be sort of like formal submission of evidence. What I will say is that in guardianship cases, the formality tends to be suspended a little bit, and there is some bits in the law that allow a judge to suspend some of the rules of evidence if it's in, I don't know the exact language, don't quote me on this. We can talk about it a little after too, if I could do a little research, but if it's kind of like in the best interest of the situation in the case, the judge can suspend some level of formality related to evidence, and they sometimes do. So I've never personally seen a video shown, but that doesn't mean a video can't be shown, because I have seen pictures be shown, and I imagine that's kind of in the same camp. Article 81 proceedings are what's called a special proceeding, and that's why the rules are kind of all over the place, and that's why people get confused with it, because the way that they don't go like normal civil cases. And there's also a lot of, obviously, like emotion and family involved in them, which is a whole added layer. So I will say yes with an asterisk. And if you want to reach out and have people from my team just take a deeper look into that, we're happy to do so. Thank you for that question. All right, so let's actually, I just realized I had one more point about incapacity before we move on. I just want to talk a little bit about ageism and ageism's role in incapacity. Ageism is just embedded in the culture of our society, right? Like, we can't pretend it's not. And it plays a big role in how some people perceive an older adult's level of functioning, and how we view the decision-making capacity of older adults. So, if you really think deep in your soul, as someone ages, do we as a society not accept risky decisions as easily just because someone is older? Do we not accept someone's mistakes as easily just because they're older and assume that we need to jump to some sort of more intense level of service? Something to think about. Even as someone starts to maybe experience a loss of cognitive functioning, which of course we know isn't necessarily going to happen just because someone is an older adult. But, if someone has a mild cognitive impairment, it doesn't mean that they can't make their own decisions. Sure, dementia can interfere with daily life and decision making, but that doesn't mean that it is. So that's part of why Article 81 guardianship is not diagnosis driven. It's about showing and telling and explaining what a person can and can't understand. So let's then go into the fourth prong, which is lesser restrictive alternatives. So the law states that a person can't be appointed a guardian unless all alternatives have been explored. So we're thinking, is guardianship the last resort? Did anything go unexplored? And here, let's go through some information about less restrictive alternatives just to get the wheels turning. There are formal and informal options. So some examples include community supports, just family, friends, religious communities. They can help in many informal ways, right? So not only home activities like cleaning, dressing, helping with food, but maybe even just helping arrange things like helping arrange transportation to a doctor's appointment, helping make decisions, just being there and talking through things, right? Just being a sounding board. Sometimes that's all people need, right? Providing emotional support, grocery shopping. These people might also be able to help create an environment where decisions are less stressful, breaking things down in a way that someone understands, taking away the pressure of time. Sometimes someone feels like they have to make a decision really quickly, and it can be difficult. And if you can give someone the time and space to make a decision, maybe that's all that they need. Perhaps someone needs to have certain conversations and make decisions at a time of day when they're more alert, right? Some people have a lot more trouble making decisions later in the day, right? Or have more issues with cognition later in the day. Some other services that are voluntary are, places that might help renew benefits or applications, heavy duty cleanings if someone's dealing with an apartment that's in an unsafe condition, home delivered meals. There are friendly visiting programs to help with isolation and socialization, even eviction prevention. And a lot of those programs might help people get on payment plans and deal with their income in a way that they maybe have a level of care that's not at the level of guardianship, but they might be able to help get bills in order. Many of these can be arranged through your local area agency on aging. In New York City, where I am, that's the Department for the Aging, but those exist in every county, and they have wonderful case management programs. Some more formal options related to personal care might be home care services or home health aides, which can be available through insurance or private pay. Visiting nurses who can help with medical care and help things like organizing and complying with medications. Adult day programs, so a person has a place to go during the day where they might be able to get a meal and have a little bit of supervision, maybe if needed. And then there is, of course, assisted living as an option as well, if someone needs a much higher level of care, and that might again be able to be sufficient to give the person what they need without having someone take over decision making. Some things related to healthcare decisions. There's not really time to go over these in great detail, but healthcare proxies, where you can appoint a person you trust to make healthcare decisions if there's a time when you're unable to make these yourself. A living will, allowing you to leave written instructions that explain healthcare wishes, particularly about end-of-life care. There's also the Family Healthcare Decisions Act, which I think it's important to bring up because we do get calls from some folks who who have a loved one in a hospital and they feel like their voice maybe isn't being heard. And according to the Family Healthcare Decisions Act, um, New York law gives authority to specific people, including family and friends, to make healthcare decisions for a person when they don't have the ability to make one for themselves. And that's if a person didn't leave instructions or doesn't have a healthcare proxy. And this law actually isn't that old. It's only, I think it's less than 15 years old. But if someone doesn't have a healthcare proxy and are in a position where they can't make a decision, there's a list of people that the healthcare facility should be going down to turn to make these decisions first before going to guardianship. I also don't think I mentioned powers of attorney. Obviously, someone who has a POA agent could make decisions on behalf of another person related to bills, contracts, etc. I do see that there is a question of power of attorney that looks a little bit long, so I'll get to it after we're done with the main portion. One second, sorry. Other things related to finances, just doing something simple like setting up direct deposit for someone to receive income. Not everyone has that set up. Automatic bill payment can take away the need for someone to take out their checkbook and pay bills. Becoming a representative payee to manage someone's Social Security benefits. Some people don't know that you can become a representative to collect someone's Social Security benefits on their behalf without being a POA agent and without being a guardian, if you show that there's need. So that's something that's also available. Then again, powers of attorney, things that are more formal like trusts, but we don't really have time to go into things that intense today. Another thing I wanted to bring up is supported decision-making. This is a practice where people make their own decisions with the support of trusted people. This is a practice that you see more in communities of people with developmental disabilities. So it can be many things, a series of practices, relationships, arrangements. Sometimes there's a formal contract explaining what decision the person needs support with and what explaining a situation would look like, what making a decision looks like. It's hard to explain because it's pretty vague, but what happens in formal support decision-making arrangements is that there is a process that is written, and it's a process on how decisions are going to be made with support. Who's going to support? How are they going to support? How is the decision going to be communicated once the supporting is done? A law just passed in New York legally recognizing this as a legitimate alternative to guardianship. So a lot of work is being done in this area right now that may add a little bit more clarity to what this is meant to look like, but also how this might translate to people outside of the community of people with developmental disabilities. If you have more questions about that, let me know, because I don't think that explanation was great. Now, this isn't necessarily an alternative, but I did want to mention that there is a type of guardianship that you don't hear being used as often, called special or single transaction guardianship. And this is, you have to get a guardian, but it's helping someone with a specific thing, like recertifying benefits or signing a lease or immigration forms. It's a very limited guardianship with a limited purpose. And what's nice about this is that it usually ends within a certain time frame. Everyone would return to court when the task is completed and the person doesn't have a guardian that's just sort of lingering after a specific situation is handled. So, these of course aren't all the alternatives that are available. And something that I want to mention is, you'll see in my slide, it says note access to alternatives. And this is even recognized in the law, but the extent to which alternatives are an option really depends on many factors like the person's finances, health insurance, age, support system, access to doctors, transportation, whether they have a social network like friends or relatives. So that's, that is something to consider. So anyway, let's say all these things are considered and someone decides, okay, someone does need a guardian. What is that going to look like? So the most basic version, and there's definitely nothing basic about this process, is who can start this case? Really anyone 18 or older who is concerned about the person. So a family member, a friend, a hospital, adult protective services. This person would be called the petitioner. And the case is started by filing papers. It's a different office depending on what county you're in, but it's the county that the person who needs a guardian lives in, not necessarily the county that the petitioner lives in, if they live in different places. So you file a bunch of papers, most importantly, something called a petition and an order to show cause. These papers give the rights that the person subject to guardianship has. It lists the powers that the petitioner think are needed to give to a guardian. It'll say when the hearing would be, who needs to be alerted that a guardianship hearing is happening. And really, you have to tell the story in these papers. Why do you think the person meets the standard? Those 4 prongs we talked about. Who do you think the guardian should be? So there's a lot more information about this online on the website that I had up there, nycourts.gov/guardianship, but filling out these papers is daunting. And as I mentioned, there aren't free legal services. We do have a helpline, but our helpline doesn't fill out papers and can't offer official legal advice, at least for now. So it can be difficult to fill these out. I will say that the court system has been working on fillable forms that I'm hoping should be out within the next year, and that should change access when needed greatly. So then what would happen is that if a judge will look at your papers, if they decide that, yeah, there's merit to this case, this needs a hearing, the judge will set a date, which should technically be within 28 days. They often will appoint a court evaluator. Now, what a court evaluator is, it's a person who's appointed to do an independent investigation. They are like a neutral third party. So their main role is to talk to all people involved and submit a report with recommendations. I will note that the court can appoint an attorney for the subject of the guardianship who in New York State is formally known as the alleged incapacitated person, or AIP. They don't always appoint an attorney for them, but that person has a right to an attorney. And if they request one or hire one, they can bring an attorney. So anyway, the court evaluator will want to talk to that AIP, will want to talk to family members. They want to make sure that the AIP understands what's happening to the best of their ability. They want to know about that person's wishes and values, whether they can meaningfully participate. They're going to try to figure out whether or not there was something less restrictive that hasn't been explored. The judge is going to tell the petitioner who they need to notify. This is called service. They're going to tell them how to do it. Do you need to send it in the mail? Do you need to hire someone to hand them papers? What I will say, some people get nervous about family members starting guardianship cases and keeping other family members in the dark. You're not allowed to do that. Could that happen in practice? Maybe. But if a judge finds out that a family member was not notified of the case, that means the case can't continue. And they are going to order that those people are served papers and given proper notice about the guardianship case. So let's say there's, family issues and someone's brother starts a guardianship case for their dad. You got to notify the other brother, right? Like you can't be kept in the dark. It's in the law. Then there's a hearing. Due to COVID, there's more virtual options that have become available and sort of stuck, depending on your county. The cases still might be done in person, or sometimes you have a choice. That's something that you would need to ask at the court. And so what the hearing is really a time for the petitioner to make their case. Everything that they wrote in the petition, it's time to tell it, show it, bring a witness who can talk about it. Who has seen these situations happen, who's dealt with the aftermath of the risky situations. And then the court evaluator, who I mentioned earlier, who's kind of investigated everything, will give their findings. The alleged incapacitated person, the subject of the guardianship proceeding, will always have a chance to make their own case or make their own statement as well. The judges usually will make a decision that day orally, but sometimes they'll do it later in writing. People often ask, how long do these take? It is hard to say because the hearing can take place in one day on that first day, but they are often adjourned, which means moved to another day or continued on another day for many reasons, like unavailable witnesses, that court evaluator, that investigator needs more time to gather information. Maybe a family member isn't able to appear, but really, really wants to be present and has a legitimate reason for not being able to appear. Many reasons, so it can take a long time. And it can be hard in urgent cases when someone really wants quick action, but the court has to balance that need for immediate intervention against infringing on the rights of a person, right? Everything in these situations are really about balance. But in the end, the judge does make their decision. Does the person meet the requirement for guardianship? And if so, who should the guardian be? So who is appointed? I mentioned earlier in filing the papers, the petitioner can say who they want to be guardian. You don't have to. If someone meets the requirements for guardianship, the judge has to appoint one and will find one. But there are a few options. So a petitioner can nominate themselves or another person, like a family member, to be guardian. The law in New York prefers that family members or friends act as guardian. It's presumed that this will be most comfortable for the person, that they might know them better, be best able to carry out their wishes. But if no family or friends are available, a judge can select a paid person who has experience in the area, or a nonprofit, like my organization, Project Guardianship. In New York City, if a case is brought by Adult Protective Services, they have a couple of nonprofits that they nominate as well. If like a family member or friend is appointed, they do have to take a course to learn about how to be a guardian and how to do required reporting. And there are a bunch of other administrative steps before a guardian can get what's called their commission and be able to act. There needs to be a final order written that's signed. Everyone has to have time to review it, make sure it looks good. You have to file a bunch of papers in the clerk's office. Once all that's done and you take that initial course, the guardian can get to work. There are some things that can be done in terms of getting power from the court earlier if there's a true emergency. Often this has to do with emergency medical decisions, or if someone's about to be evicted from their home. Someone can be appointed what's known as a temporary guardian or an interim guardian. Those are a bit more complex and have a very high standard, but those are possible. But anyway, it can take a very long time for a guardian to be able to act. And this brings me to one of our final things, which is limitations. What can a guardian not do? First, let's talk about mental health treatment. A guardian cannot have the power to consent to psychiatric treatment over someone's objection. So that's psychiatric medication, inpatient treatment, or admission to a facility. They can't also consent to drug treatment. The state really takes body autonomy extra seriously, and I think people are surprised and sometimes disappointed to find out that you can't override someone's objection to mental health treatment. It's hard. There are mechanisms in New York State that can be used for involuntary mental health treatment, but they are the same whether someone has a guardian or doesn't have a guardian. Something that I always do mention, though, is that even though a guardian can't consent to this type of treatment over someone's objection, they can help arrange it if that's part of the barrier. They can help deal with other stressors that might be occurring in the person's life that maybe are preventing them from saying yes. Maybe there's like instability in other areas that's making it so that they can't focus on the thing like drug treatment or mental health treatment, and they keep saying, I'm going to do that later. So, I have seen that happen and make it so that the person is able to consent or willing to consent later. But again, they can't consent over someone's objection. Another thing that can be considered a limitation is that in practice, a lot of time, a guardian does need the court's permission to make major decisions, even if they have those powers. So sometimes like making major medical decisions, like consenting to voluntary surgeries or relocating someone to a more restrictive setting, like if the guardian is thinking that someone needs to move to assisted living or especially move to a nursing home, the judge is usually going to want to hear about the situation and approve before that happens. Another thing is just guardianship happens in the real world. A lot of people out there don't understand it. So a guardian might be trying to do something with a third party, like a bank or something, and they might not accept that the guardian has the power that they have, even if they show them the court order, and this can cause delays in places like banks, hospitals, and it can take a lot of time and effort to educate people. So that's another thing, is that we have to remember this is the real world. Another thing is you can't change a person's personality. So, you know, a guardian can't be there at a person's home every day to open the door for the service that they've arranged. And it can be hard, but people are still who they are, right? And this isn't a magic wand to change how a person is. And as I mentioned, guardians can't act immediately, so it can take a while. I know this is a lot. I know we do have some questions in the chat. This is why I do want to give you information about our guardianship prevention and support helpline. It's open from 10 to 1 daily, and we also have email and a web form and voicemails. We have 2 attorneys who are working on it full time, and we also just recently hired a new attorney who is going to be with us full time very shortly. She's on here right now, and they are wonderful. The 2 attorneys who are working full time both have years and years of guardianship experience, and I work with them as well. And if we don't have answers to your questions, you know, spend a lot of time asking others, doing a little bit of research. So please feel free to reach out or refer other folks. We can communicate in 120 different languages using phone-based translation, and we do quite often. One thing I do want to note is that, again, this is not creating an attorney-client relationship. The helpline is not meant for, you know, use along every single step of the way in a proceeding, because then that kind of makes things murky and creates an attorney-client relationship. But we can talk people through the process, answer questions about forms. This is also both for people from the public, you know, dealing with family and friends, and also professionals. We get calls from, you know, case managers, social workers, doctors all the time. So again, we can explain court processes and papers. We can give caregiver support and kind of brainstorming other options and alternatives. Sometimes people call because they're having an issue with the guardian, and we do the best of our ability to explain the different channels that can deal with issues with guardians. We give referrals to other organizations. A lot of people call looking for attorneys. Unfortunately, you know, we can refer people to sort of hubs where they can find attorneys, but we don't have specific elder law attorneys that we work with. And again, there's not free legal services for things like this. If people have guardians, we welcome for them to call us as well. I find it really frustrating that when someone who has a guardian calls a place for help, that sometimes when they find out that they have a guardian, they just want to talk to the guardian, and like, people are people, right? So we take everybody's concerns seriously. And we've been open for a little over a year, and I think are close to 750 inquiries. So it's a lot. So again, that's why I mentioned, you know, it can be hard. Like, we can't have long-term relationships with people, because right now we not only do we not have the time because there's so many people calling, but also because of we're not able to have an attorney-client relationship. But any question you might have, just give us a try and we'll do the best we can. And we're also, very willing to tell you if it's a little bit outside our scope, but we definitely are willing to go a bit outside of our scope. Anyway, here's the contact information again. So you have it, 718-750-8474, and it's helpline@projectguardianship.org. You can find more information about the helpline at projectguardianship.org/helpline. And you can find more information about our organization here on this page at projectguardianship.org. And now we have time for questions. I know it's getting close to 1. Technically, this presentation is until 1:15. I'm not sure if that was mentioned, but I'm here for your questions. I do see someone asked if the PowerPoint presentation is available. Yes, we can make it available as long as someone from the Alzheimer's Association can send it out. I can send a PDF of it. So no worries, Karen. Thank you for asking. All right, so I am going to go up to the top, and I see that there are a couple of questions. If you have more questions, please feel free to put them in the chat, and I will be here till 1:15. So I'll answer to the best of my ability. Karen says that she has a power of attorney. But you worry about the future. You want my daughter to be able to take over. Got it. So there actually is a way to put another person on power of attorney forms, so that you can set this up. Since I would want to ask a bunch of questions to follow up on what's on the form and the what it looks like. I would love for you to reach out to the helpline so that we can get more specifics about your information, and we can talk about what's available. I know that you're expressing that it's too late. It sounds, since you're asking all of these types of questions and looking for answers and things to do, it doesn't sound like it's too late. So yeah, please reach out to the helpline, and we'll try to figure out what a good direction is. Another question we have is, what if a judge has never explored less restrictive measures? A guardian was appointed after petitioned by a hospital, but there were no capacity issues. The guardian placed the person in a nursing home and takes their Social Security money, but nothing else. Property and personal, you mentioned removal of guardian. How does that happen? So there's information about how to go about removing a guardian I'm going to put the website on here so it's easier to get to, newyorkcourts.gov/guardianship. There is a part on there that's called ending or terminating or changing a guardianship. Sorry, I'm having trouble getting my sound to turn off. Yeah, there's information on there for ending or changing a guardian, and it will give you some guidance on what that process is like, making a motion, etc. And then it'll also give you the language to use when you're reaching out to your court to ask them for paperwork. Usually you have to file some sort of motion asking for the guardianship to end or for a change in guardian. It says final order about to be entered, so I'm not sure if there's a court examiner yet. When a guardian is appointed, someone called a court examiner is appointed. Sounds very similar to court evaluator. I wish the language sounded different. It's not, it's different. A court examiner is someone who's appointed to oversee the guardian and look at formal reports that the guardian has to file. So they'd be a good person to ask, but if a final order is about to be entered, yeah, I mean, if it hasn't been signed yet, you can reach out to the court and challenge that final order. Okay. Someone mentioned about having legal guardianship over their father in New Hampshire, but he now resides in New York. A woman married him in New Hampshire before the pandemic, and they didn't know about it, and he doesn't have a memory of this, and the woman is contesting legal guardianship. and you're not able to annul it, even though he's now deemed incapacitated, how hard will it be to change the guardianship to New York State? Yeah, I mean, if he's living in New York State with you right now, the guardian should be in New York State. We get calls about changing guardianship to New York State or out of New York State all the time, and can talk you through the process. So I, again, am going to recommend you reach out to the helplines so that they could talk to you about how the specifics go. But essentially what will happen is that you will reach out to the court in New York, who will kind of be on notice about the guardianship being transferred, and you'll get something from New Hampshire kind of like relinquishing it, saying, yes, we are transferring to New York. That order is then given to New York, who then accepts it. Obviously, I'm oversimplifying it right now. But our helpline attorneys can talk you through the process, and also who exactly at the court you should contact, who will explain the right type of papers that you need to file. Again, these things don't happen overnight, but there is a very specific process for this. So I hear you, and that's very frustrating. The next question is, what about when someone with early stage dementia doesn't have anyone in their life to appoint as POA or healthcare proxy? Can they set up guardianship while they still have capacity, anticipation of the future? This is a very good question, Ronnie. I personally think about that a lot. So there actually are, in terms of power of attorney and healthcare proxy, there are folks out there who are willing to act as a POA in paid programming. I'm not sure if you're talking in theory or talking about specific individuals. For example, I know of a financial management program that's out of Lifespan up in Rochester, and they will actually act as power of attorney for a very, very low fee comparatively for people. And they'll actually, so the thing that's nice about powers of attorney is that the person who has the power, who's called the agent, they don't have to act, right? So if you appoint someone a POA agent, so if I appoint my sister, my POA agent, I can still continue living my life, making my decisions. It's just that she now has that power. So when it comes time where I can't do that stuff on my own, she can now do it. So this organization that I bring up, they will become the POA agent, and then later, when it's time that the person can't do as much on their own, they will become them. I don't know how far out that program up there goes. It's something that, again, I think about and we talk about at our organization, because it's a problem. A lot of people don't have someone to appoint as POA. There are people who you can pay. There's an organization that a professional association called like the Money Managers Association of America, I think it is. And a lot of those people do multiple different things in the money manager and financial space. And I know a lot of those people can be paid to be power of attorney. I'm not sure about healthcare proxy. But as I mentioned earlier, there is that Family Healthcare Decisions Act that has a long list of people that can make decisions if you're unable to, which can include, like a friend as well, even if it's someone who's maybe not willing to take on that extra responsibility of being a full healthcare proxy. There's a list of people who can make decisions in the healthcare setting should you not be able to do so. With respect to setting up guardianship while someone still has capacity, the law is not set up for that. The thing is that when someone is appointed a guardian, the power that the guardian gets, the person no longer has. So it's not something that you can set up in advance, because once a guardian is appointed, it's not something, there's no such thing as an order that will trigger the powers going into place when a certain condition is met. And that's tough. Because this is not the first time that I have been asked this question. And I think people who want to do that, want to be able to have some say in their future. And it's frustrating to not be able to have things like that happen until it's time. But someone who is wanting to consent to a guardian has to be okay with the fact that that person's power goes into effect immediately once the order is signed. So that's something to think about. And even if you're consenting to a guardian, the judge will still want to see that there's a need. They're not just going to appoint a guardian because someone says they want one. They need to see that there is a need now. But it's tough. These questions are so good, and they are showing so many gaps that we have in New York State. I think can guardianship in the US be recognized in other countries? So it's hard for me to know, because I think it depends on what country. I will say that here in New York, I've gotten calls related to people wanting a guardianship to be recognized here from another country. So as someone mentioned before about transferring something from New Hampshire to New York, you also can transfer a guardian from another country. I've never personally seen it done, but I know that you can, and I've spoken to someone at the court to actually confirm that that's something that can be done. I'm not sure what happens if, for example, let's say someone has a guardianship order from a judge in Greece, and then they're here and someone needs to make a decision while the person is here temporarily. I don't know what that looks like. And I would actually be curious to talk to someone from a courthouse and see what happens and what that looks like in real time. So Carlton, if you want to reach out and ask the question to the helpline, again, the helpline is something that I, to a degree, oversee as well. So any question that comes in there from this presentation, I will see. I'm not just trying to pawn you off on someone else. I'm happy to have our team look into that so we can get a more practical answer there. I'm gonna start bouncing around a little bit. Someone asked a question, are guardianship laws universal across the country or vary state by state? Great question. They vary state by state, which makes things incredibly difficult. Sometimes the language isn't even the same state to state. So you'll see that in some states, they'll call financial or property guardians conservators. Before the 90s, in New York State, they used to be called conservators, and then the language changed. So the standard that I talked about with all those different prongs, those 4 prongs, the standard for guardianship is different in different states. You'll definitely see a big overlap. But the standards, the process, the language, it is a state by state sort of thing. All right, let me keep going. How easy or difficult is it for a secondary person to replace the initial guardian without authorization? I think I need a little more context to that question. I'm not sure what you mean by authorization. So Yvette, if you're still here, if you can add a little clarification, I'm happy to give that answer a shot. I love this question. Tanya has said, a comment just from my experience with guardianship, there are 3 different languages, legal, medical, financial, and they don't speak nicely to each other, meaning it's not a universal language and easy to navigate through. Yeah, speaking to the at least one person choir, I agree. Part of why I do some of the things like this is to just try to at least break down this information a bit and set expectations. But you're right. Not only are people sort of speaking different languages and using tons of jargon, they sometimes don't want to listen to each other or don't believe each other or think they know more about the other group's processes than the own group itself. And it's frustrating. And again, why I'm always trying to set realistic expectations for people that all this stuff is incredibly hard and confusing, even to people like me who have been doing it for 11, 12 years. Oh, thank you, Yvette. If a different family member wanted to take over for the initial guardian, how easy or difficult it is. So the person would have to file a motion to substitute the guardian. And depending on what county you're in, that motion would look different, but like a pretty simple form. But you would need to show why that guardian can no longer be guardian. And there is a list of reasons. And you can't just say, I would do a better job. Like you need to show that the person was ineffective, or that they've, obviously, if they've done something to harm the person, or if they've been neglecting their duties, or if they've kind of like gone against their what's known as the fiduciary responsibility to the person. If they haven't, there's a really long order that says all the things the person have to done. If you show that the person's not doing those things, then yeah. Also, it's possible that the person who's guardian, maybe you have a nice relationship with them and it's becoming too much. If you want to go together and say, I'm trying to substitute because it's becoming too much, that's, you know, that's something that can be done as well. So it could be as simple as just a motion and a quick hearing. But I say it could be because nothing is ever that simple. But if that's something that is happening in your life, or someone that you're talking to or working with, definitely another thing you can reach out to the helpline and we can talk to you about what that process looks like. So we're getting towards the end. Anything else? Well, thank you so much, everyone. Thanks again to the Alzheimer's Association for having me and having me come for a second time. I love these questions. It just, I like the way that everyone's thinking really critically about these issues, and just pointing out the things that are big gaps and are difficult. And I'm thinking about them and working on them. And I promise that there are people out there who care about these things and are doing their best. Really, any question you have at all, please reach out to the helpline. Really like wonderful, kind attorneys on there. I think that's been a big hiring perk and bonus that we've had, is that we found really, really wonderful people who have a lot of knowledge, but are also extremely compassionate. So reach out with a question, and you know, thanks again for being here. And that's it. I don't know how to end. Thank you. Thanks,
Thank you, Jean.
Michelle. That's a very nice comment.
Great. Thank you so much, Dina, and also thank you, Paige, for the awareness presentation earlier. And want to thank you all for joining us in today's program. In the chat is all the resources, and you'll also be getting an email with just all the information that Dina has spoke on, and also the resources from the Alzheimer's Association. So again, thank you all for joining us, and I hope you guys have a great rest of your day and week as well. Bye, everyone.
Thank you.